welcome back to another Explainer. I am absolutely thrilled to have you here today because honestly, we're looking at something that is truly foundational. So often we think of the Constitution as just this dusty historical document sitting in a glass case somewhere. But today, we're going to reframe that entirely. We are looking at the Constitution as a practical, everyday toolkit for citizens. If you've ever wondered how the words on those pages actually protect you in the real world, you are in exactly the right place. Let's get into it.
Okay, really quickly, here is our roadmap for today. 1. The heart of the Constitution. 2. The procedure. 3. The 5 constitutional writs. 4. Supreme Court versus High Court. 5. Public interest litigation. And finally, 6. Rights during an emergency.
Section 1. The heart of the Constitution. Why rights need remedies.
So, let's start with a foundational problem. Imagine having a shiny, brand new sports car, but you literally have no keys. That is exactly what a right is without a remedy. It's completely useless if you have absolutely no way to enforce it in the real world. And that is exactly why Dr. B.R. Ambedkar, the chief architect of the Indian Constitution, referred to Article 32, which is the right to constitutional remedies, as the heart and soul of the Constitution. He recognized that this specific right was the very lifeblood of the entire system, because without the ability to enforce them, every single other fundamental right is just an empty promise.
And this brings us straight to the concept of judicial review. Basically, this is a mechanism that empowers the courts to strike down unconstitutional laws and protect individual liberty. It prevents arbitrary state action, ensuring the rule of law actually means something. It's so absolutely vital that in the landmark Keshavananda Bharati case, the court ruled that judicial review is part of the basic structure of the Constitution, meaning there is no way it can be amended away. We see its power super early on in cases like Romesh Thapar, where the Supreme Court made it crystal clear that Article 32 is the ultimate safeguard for protecting our fundamental rights.
Section 2. The procedure. How enforcement works.
Now that we have the theory down, how do you actually knock on the court's door? Well, the legal procedure to enforce these rights is brilliantly structured and logical. It takes a grievance from a simple complaint all the way to a binding resolution. Step 1. The aggrieved person files a writ petition stating exactly which right was violated and what relief they want. Step 2. The court issues a notice to the government or the authority involved. Step 3. Both parties present their arguments in a hearing. And finally, Step 4. The judicial remedy. This is where the court can issue writs, strike down laws, pass directions, or even award compensation. It's just a clean, direct pipeline to justice.
Section 3. The 5 constitutional writs. Your toolkit.
All right, let's officially open up the box and look at the actual tools you have at your disposal. These tools are called writs, which are formal judicial orders originating from English common law. The first, and honestly probably the most famous, is habeas corpus. In Latin, this simply translates to produce the body, which I know sounds a bit dramatic, maybe straight out of a mob movie or something, but it's actually your ultimate protection against illegal detention. If someone is unlawfully imprisoned, the court orders that person to be brought physically before them. And to show you how powerful this really is, in the Rudal Shah case, this specific writ wasn't just used to free someone. The court actually awarded financial compensation for the illegal detention. It's a massive protection.
Our second tool is mandamus, which translates to we command. Have you ever dealt with a public authority that just simply refuses to do its legal job? Well, this is the tool citizens use to force action. If a public official or a public body has a mandatory duty and they just fail to perform it, a writ of mandamus legally compels them to get off the bench and do their job.
Now, what is really fascinating here is the contrast between our next two tools, prohibition and certiorari. Both of them deal with lower courts or tribunals stepping way out of bounds, but they operate on completely different timelines. Prohibition is preventive. It's issued by a higher court before a final decision is even made, basically stopping a lower court from exceeding its jurisdiction. Certiorari, on the other hand, is corrective. It's issued after a decision has already been made, allowing the higher court to completely quash, or basically erase, an unlawful order that violated natural justice. So one stops the error from happening and the other erases an error that has already occurred.
And our final tool in the kit is quo warranto, meaning by what authority. This acts as an incredibly powerful shield against administrative excesses. If someone is sitting in a public office but doesn't actually legally belong there, this writ allows the court to examine the legality of their claim. It essentially asks, hey, who gave you the right to sit in that chair, and prevents the unlawful occupation of power.
Section 4. Supreme Court versus High Court, the guardians.
So we know the tools, but who actually wields them?
The crucial point here is the contrast in power. We have Article 32 for the Supreme Court and Article 226 for the High Courts. Approaching the Supreme Court under Article 32 is a fundamental right in itself, and it's available throughout all of India. But its scope is actually narrower. It's only for fundamental rights. However, if you look at Article 226, the High Courts actually have a wider scope. They can issue writs for fundamental rights and for other ordinary legal rights within their territory. This dual guardianship is incredibly robust, an amazing detail that was affirmed as part of the basic structure in the L. Chandra Kumar case.
Section 5. Public Interest Litigation, Expanding Access. Now all of this brings up a massive question. Who actually gets to pick up these tools and use them? For a long time, the legal system operated on a really strict rule called locus standi. This meant only the person directly injured could approach the court. But what if the injured party is too poor, or marginalized, or unaware to fight for themselves? Well, the judiciary totally revolutionized Indian law by relaxing those strict rules, giving birth to public interest litigation, or PIL. Now, any public-spirited individual can approach the court on behalf of weaker sections. Cases like S.P. Gupta massively expanded this access, and the Bandua Mukti Morcha case really proved its power when the court relaxed procedures specifically to protect bonded laborers who couldn't protect themselves. They literally threw the doors wide open.
This flexibility totally opened the floodgates for social justice. Through PILs, the courts have been able to tackle massive societal issues: environmental protection, prison reforms, child and bonded labor, women's rights, and corruption. For instance, the legendary environmental crusades led by MC Mehta were heavily fought through PILs. However, to be totally impartial here, this expansion is definitely not without its critics. Opponents validly argue that PILs can sometimes lead to judicial overreach, an influx of totally frivolous petitions, and even political misuse, placing a pretty heavy burden on the judiciary. But despite all that, it remains an undeniable, absolute game-changer for human rights enforcement.
So, we have this incredible, dynamic toolkit that guarantees our democracy. But what happens when the whole system goes under extreme stress? What happens to these specific constitutional tools during a national emergency?
Section 6. Rights during an emergency. The ultimate stress test.
The Constitution actually contains specific emergency provisions under Articles 352, 358, and 359. And the reality of this is honestly quite terrifying. Under Article 358, the freedoms guaranteed by Article 19 are automatically suspended. But far more crucially for our toolkit, under Article 359, the President may suspend the very right to move the courts for the enforcement of specified fundamental rights. Essentially, during an emergency, the state has the legal power to just lock your toolkit away. No keys for the sports car.
Let's trace how this builds through history, because it reveals exactly why this is so terrifying. During the national emergency of 1975 to 1977, there was a well-documented, heavy misuse of these suspension powers. This culminated in the highly controversial 1976 ADM Jabalpur case, where the court literally held that citizens could not seek a remedy for unlawful detention during an emergency. Even habeas corpus was deemed totally useless. It was a remarkably dark moment for civil liberties and heavily criticized later on. But look at 1978. The 44th Constitutional Amendment Act steps in as the ultimate legal correction to ensure that something like that never happens again.
Because of that 1978 amendment, we have a vital, permanent safeguard today. Even in the absolute darkest days of a national emergency, Articles 20 and 21, your fundamental right to life, your personal liberty, and your protection against arbitrary punishment can never be suspended. The most critical parts of your constitutional toolkit are now permanently indestructible. They remain protected, preserving the essential baseline values of democracy and the rule of law, no matter what the crisis is. And that brings us to the end of our explainer. We've seen how Articles 32 and 226 form this incredibly dynamic system of writs, PILs, and judicial review. We've seen that the Constitution is definitely not some static, dusty piece of paper. It is an active, living toolkit deliberately designed to protect liberty and equality. So, my final provocative question to you is this. Now that you know these tools exist, how will you use this toolkit to protect the rights of those around you? Think about it. Thank you so much for exploring this with me today, and I will catch you in the next explainer.